judgment on sentence delivered on the day. Mr. Rohde, on the 8th of November 2018, this court found you guilty of the murder of your wife with the direct intention to kill her, as well as defeating the ends of justice by staging her body and the crime scene so as to appear that she had committed suicide, and supplying false information to the police in order to mislead the investigation as to the true method of her death and that you had murdered her. Now is the time for me to mete out an appropriate sentence to you for the crimes of which you had been convicted. The determination of a suitable sentence does not entail a mechanical process in which predetermined sentences are imposed for specific crimes. In each case, the sentencing court has to take the appropriate weight thereto and strike a fair balance between the things of factors. In the off-court brackets, court must therefore take into account your personal circumstances as the accused and the person convicted of the crimes, the nature of the crimes which you had committed, including the gravity and extent thereof, and the interests of the community. In determining such a sentence, the court must tinge the sentence with a measure of mercy and strive to meet the objectives of punishment, which is retribution, prevention, deterrence, and rehabilitation. The general rule, as held by the Appellate Division in State v. Rohde, 1975, Volume 4, SA, page 855 AD, is that, and I quote, punishment should fit the criminal as well as the crime, be fair to society, and be blended with a measure of mercy according to the circumstances. In mitigation of sentence, your counsel, Mr. Van Spey, led witnesses and had also placed factors before me which I should take into account in order to impose a lesser sentence to you in respect of the crimes of which you had been convicted, other than that in respect of count 1 that is prescribed by the law. Counsel for the State, Mr. Van Niekerk, on the other hand, led evidence and made submissions which in his mind are aggravating and warranting of the imposition of a harsher punishment. The legislature, otherwise known as the lawmakers, have recognized that certain serious crimes must be met with a minimum sentence. You have been convicted of murder, falling under Part 2 of Schedule 2, and as a first offender of this type of crime, you should be sentenced by the court to a minimum sentence of 15 years imprisonment, and that is in terms of Section 51, subsection 2A of the Criminal Law Amendment Act 105 of 1997, commonly referred to as the minimum sentence legislation. The court do, however, have the discretion to impose a sentence lesser than the prescribed minimum if it is satisfied that substantial and compelling circumstances exist which cumulatively justify the imposition of a lesser sentence. Whilst I am empowered to deviate from the imposition of the prescribed 15 years, I cannot do so for flimsy reasons, nor depart from same lightly. As set out in State v. Malchus, 2001 SACR, page 496 SCA, I need to be satisfied that the imposition of such a sentence would not be disproportionate in the circumstances, and I must likewise be satisfied that the factors warranting a lesser sentence is of such a nature that it is substantial and compelling in its justification to depart from the prescribed sentences. In other words, the 15-year sentence is to be regarded as generally appropriate for the crime of murder of which you had been convicted of, and should not be departed from without weighty justification for doing so. I have, in the written judgment available on my registrar after this, set out some case law in which I draw that guidelines from. The court, by the same token, is also empowered to impose a sentence in excess of the prescribed minimum if the circumstances and applicable factors of the case warrant so. I had, as you would have heard at the start of closing submissions, ventilated with your counsel and counsel for the state that an appropriate sentence could possibly, in these circumstances, warrant of this court to exceed the prescribed minimum sentence, taking into account the aggravating features of the murder in respect of which you had been convicted. Both counsel were given an opportunity to address me on this aspect, and the matter stood down for a period so as to afford each an opportunity to take adequate instructions, and they had addressed me on their submissions in that regard. I will now turn to the triad of factors, starting with your personal circumstances, as had been highlighted, which had been called. In respect of your personal circumstances, you are presently 50 years old, and you were 47 at the time of the commission of the offences. 3 daughters are born between yourself and the deceased, one in June, and twins who had recently celebrated to society, that they know of you to be a good, caring, and similarly, you are kind and helpful to your family and friends alike. They do not know you to be disloyal or dishonest. They do not know you to have an aggressive. However, Dr. Stoloff, a mitigation wife, he testified before this court in December last year that during his last assessment, you did observations, you are modest about your achievements, kind, even-tempered, and to his knowledge and understanding, you do not have characteristics of violent or controlling behavior. That's so much, Mr. Rohde, about your personal circumstances. I now turn to the second factor to be considered, that being the crimes of which you had been convicted. And specifically, I look at the manner of execution thereof, as well as the nature, the seriousness, and the impact thereof. The victim of these offences was none other than your wife, whom you had been married to for 22 years. The murder of your wife was callous, it was brutal and shocking. Susan died a painful and gruesome death. She did not die instantly. It took her a while to die. She suffered in the last moments of her life, eventually succumbing to her death. The degree of violence which you had meted out at your wife was egregious. It was excessive and exhibits horrifying aggression. You executed successive blows and fatal force in the taking of her life and completely disregarded her bodily integrity. It is a significant feature of this crime that you did not hesitate and did not call for medical, and you waited for her to die. I will deal with this in a little bit more detail later in this judgment. The court heard throughout this trial and sentencing proceedings about the big loves in your life, from marrying your childhood sweetheart, the deceased, to the relationship with your mistress, Jolene Altersky, then to the realty business in which you had been so successful, the love and care for your friends, the care for your domestic employee, your community, and sport. Yet, during the commission of these crimes, that is the story of malignant self-love, the love for yourself. In the course of murdering your wife and setting the scene that she had taken her own life, no other interests, desires, and care mattered than that of your own. You did not just take Susan's life, entity thereof, and what her life meant to herself and to those who loved her, your own daughters, and the father of her children for protection and security. Her guard and defenses would have been down, being in the sanctity of comfort. You did not testify in particular remorse for the murder of your wife. Had you done so, it would have been taken into account as a mitigating factor. That you elected not to do so will, however, not be viewed as an aggravating factor. However, it bears to mention, your counsel invited me to consider the personal circumstances as had been led during the trial, in addition to that which was presented during proceedings in mitigation of sentence. Accordingly, I revisited your testimony during the trial. At the conclusion of your evidence in chief on the 30th of May 2018, almost 2 years to the death of your wife, you elected to make a statement to this court. In response, I asked you the following question, and I state this with quotation marks, quoting directly from the record 12 until 242795. What does the absence of Susan mean to you, sir? Was essentially that you have not had the time to grieve her death as you are fighting for your life. This is illustrative, in my view, to be contrary to the deep and caring manner of which your witnesses in mitigation has testified to. Mr. Rohde, is glaringly a loss to your children, her family, her friends, the community circles in which she assisted, the voluntary reading and maths lessons she offered to underprivileged children, the time she offered to the Hearts of Hope orphanage, and voluntary counseling of crime victims, to mention but a few. It is further clear from the evidence that Susan loved life. She loved her family, her friends, and her community. She was passionate about her hobbies, running, gymming, her love for horses, and contributing to the underprivileged. Her death means she is no longer able to do these things, and that she is missed for the role she played in the lives of others. Instead, Mr. Rohde, to you, and according to you, her death means that you have to fight for your life. This is by all accounts a very selfish and self-serving manner of perceiving the death of your wife. The victim impact report prepared by probation officer Mr. Rian Perry, whom interviewed your daughters, reported the absolute loss which they feel following their mother's death. I refer to Exhibit MM, page 14. Your eldest daughter verbalized that when she wakes up in the morning, she realizes anew that her mother is not there anymore. Causes her to experience a sinking feeling in her stomach, followed by her feeling ill and empty. Her mother's death has affected every aspect of her life, she said. She longs for the closeness of her mother and the emotional support her mom offered her and provided. She described her mother as having been a source of stability in her life, someone she could fall back on, and someone who did everything for her children. Your children live in fear of their future well-being. They suffer the conflict of mourning the death of their mother and supporting and loving you as their father, which in turn creates ongoing confusion and distrust. Whilst it is undeniably a difficult position for them, the court has also heard that they are incredibly strong young women, that they are well loved and cared for, and that their reasonable financial needs, until they become self-supporting, would be met by the deceased estate of their mother and the children's maternal grandparents. Submissions had not been made on your behalf as to what financial contributions you would be making to their future financial needs. However, it is common cause that you hold a 25% shareholding in a realty business, and that notwithstanding your incarceration, you have an obligation to maintain your children until they become self-supporting. On the topic of your financial position, I pause to add that your counsel argued, amongst other things, that the life of luxury to which you are accustomed to and your economic wealth ought to be considered as a mitigating factor in imposing a lesser sentence. Imprisonment, he argued, would be devastating to the liberties and privileges which you are accustomed to. This is, with respect, a preposterous and nonsensical submission, to which I cannot disagree more. It is a constitutional and fundamental principle of our law and our democracy that we are all equal before the law, irrespective of our class. The guiding principle that the punishment must fit the accused, the crime, and the interests of the community simply does not mean that the privileged and wealthy sectors of our community ought to get favorable sentences given their fortunate economic background. A similar argument was made on behalf of tennis icon known as Mr. Bob Hewitt. When the wheels of justice caught up with him, he stood to be sentenced for his crimes. Much was made by his counsel, similar to that of your counsel, that he is standing as a tennis icon who successfully represented his country internationally, and his standing in society makes imprisonment of such an individual improper because his fall from grace and the pain of the trial was in itself punishing. This submission on behalf of Mr. Hewitt was dismissed by the trial court as well as the appeal court, in that it overlooks the basic tenets of the Constitution, which enshrines that we are all equal before the law. Similarly, your life of luxury and the wealth and the liberties you are accustomed to cannot be a factor to be considered in determining sentence of imprisonment. In this respect, I refer to Hewitt v. S. 2017, Volume 1, SACR 309, SCA at paragraph 315, and I quote at paragraph 14. Lastly, the last factor to be considered, the interests of the community. With regard to the interests of society, it is undeniable that we are experiencing high levels of violent crime, and in particular, with reference to this case, violent crime against women. Dr. N. Abrams, the Acting Director of Gender and Health Research Unit of South African Medical Research Council, testified in aggravation of sentence on behalf of the state. She testified on national and international studies that she was part of, as well as the research on female murders and intimate femicides. Intimate partner violence is the most common form of violence women experience in this country. Femicide, she testified, is the killing of a woman, and in particular, her studies related to intimate femicide, which is the killing of women by their intimate partners being husbands and boyfriends. Dr. Abrams set out in her report, handed up as Exhibit LLLL, and testified that a study that looked at women killed globally in 2013 revealed the following statistics. The data from 66 countries found globally that 39% of homicides of women are committed by their intimate partner. This is clearly quite disproportionate and alarming if you look at it being compared to that of South Africa. The proportion of intimate partner homicides in our country stands at 59%. We have, Mr. Rohde, because of crimes like that which you have been committed of, become the femicide capital of the world. This is clearly an epidemic, an enormous social problem. According to a study set out in an article titled Female Homicidal Strangulation in Urban South Africa by authors Sophia van Niekerk and Arendse, they state at the conclusion of the article, and I quote, "The prevention of female homicidal strangulation in South Africa will ultimately be strengthened by the creation of a social milieu that promotes equity, safety, health, human rights, and justice. It is thus important and the duty of the courts, as so highlighted by various other cases on similar matters, to contribute in our role as the justice system, to impose appropriate sentences, particularly where women are murdered in the context of their marriages, their relationships, their homes, and private space. Whilst it is so that you, as the accused, cannot be sacrificed at the altar of deterrence for other would-be offenders, nor can I impose punishment in anger, which I don't, the interests of the community must be satisfied that offenders of serious crimes such as these be punished accordingly. If offenders are punished too lightly for serious offences such as these, society would lose confidence in our courts, and so too would law and order be undermined. Serious crimes of this nature, therefore, compel that the objectives of retribution and deterrence weigh more than the objectives of rehabilitation of the offender, and according to the interests of the accused, would recede into the background. I quote from similar sentiments from different cases, one of which is State versus Van Staren, a Kimberley High Court decision. The court states in paragraph 14 of its judgment, and I quote, "Murder committed by a man on a woman should not be treated lightly. It becomes worse where the perpetrator, as in this instance, was the deceased partner, who had the duty and the responsibility to protect her and not to harm her. It is killings like the one committed by the accused, which necessitated the imposition of sentence to serve not only as a deterrent, but also as a retributive effect. Violence against women is rife, and the community expects the courts to protect women against the commission of such crime." Close quotations. In conclusion of this factor of the triad, it is pertinent to note that it's been 20 years or more since the Supreme Court of Appeal so articulately stated in State versus Chapman, 1997, Volume 3 SA, and I quote, open quotations, "Women in this country have a legitimate claim to walk peacefully on the streets, to enjoy their shopping and their entertainment, to go and come from home, and to enjoy their peace and tranquility of their homes without the fear, the apprehension, and the insecurity which constantly diminishes their quality and enjoyment of their lives." Close quotations. Now I go on to specifically deal with certain aggravating features. The aggravating features of the murder of your wife are significant and startling. I will set them out briefly as follows. You murdered Susan with the direct intention to kill her. She looked to you for protection and would have trusted you to care and protect her. Instead, you breached this trust, attacked and murdered her in your private space. Your counsel argued on your behalf that the murder was not for financial gain, but was a crime of passion, which ought to be viewed as mitigatory. Susan, he argued, pursued your infidelity with proactiveness and with interrogation. The suggestion is that your wife ought to have been more subservient and accepting of your infidelity and ought to have restrained her objections and interrogations. That she did not do this resulted in the perfect storm of your quarrel, and it was in the exigencies of these events that the offences happened. She got killed, and you ought to therefore get a lesser sentence, the argument follows. I cannot disagree more. This is a patriarchal and antiquated viewpoint that at some point many years ago was part of our justice system. It undermines women, and in the context of intimate femicide, a wife or a girlfriend's right to dignity and equality before the law. Intimate femicide clearly cannot be viewed as being conduct which is less morally or legally reprehensible. You were her husband, the father of her children, and you were required to protect her rather than to inflict harm upon her. The injuries which you inflicted on your wife were successive and incremental until it was fatal. During this time and in the progress of killing her, you would have had time to reflect and desist from your unlawful conduct. However, you carried on regardless. The extent of the force which you used was so excessive that the injuries to her neck shows clear grab and scratch marks and bruises on the surface of the skin in that area, with deep hemorrhages in the underlying tissue layers caused by your thumb on the right side of her neck and the remaining fingers on the other side of her neck. Her rib cage had various fractures, illustrating how you had applied substantial force on her chest, most likely with your knee, whilst you manually strangled her, incapacitating her in the process. So severe was this force that she suffered a contusion to her lung. It resulted in internal bleeding, coughing blood, swallowing it, and ingesting it. The pillow which you used to smother Susan was done with repeated action. This is illustrated by the seepage of blood from the abrasion you caused on her left upper eyelid by an earlier fist punch. which had come off onto the pillow twice as you pushed down on her face repeatedly. With your force pressing down on her face, you deviated her nose to the right and caused her teeth to cut into the inside of her lower lip. It is significant and a disturbing fact that throughout this ordeal you did not call for medical assistance. When you ultimately did call for help, you limited it to a handyman purely for the purposes of furthering the commission of your offences. At no stage do you question, hesitate, or become ambivalent about murdering your wife. You forged ahead, unfettered, nor restrained by conscience or reflection. These aggravating features are so extreme and shocking that in my judgment it far outweighs your personal circumstances and other mitigatory facts, to such extent that it warrants a sentence in excess of the prescribed 15 years. I will deal with that further in my conclusion. As regard to count 2, which is the conviction for defeating the ends of justice, the features are indeed also aggravating and remarkable. The court has heard that you are a business engineer of note in the property and realty industry. Marketing and selling of property is your strength. Posing and pitching the sale of a concept is the golden thread of the realty world. Showing property for sale as show houses is a skill which determines the success of the sale. I looked through various websites of property industries, of which you were a shining star, and I see that many estate agents, and I quote from one in particular, Rosie Mulvaney, who sells properties across Ireland, and on their website quotes the following: you get one chance to make an impression, and preparation is key. And so I also looked at the Sotheby's Lou Geffen website, of which you were the former CEO. And their sentiments are exactly the same. They say staging is a key element in selling property. Gleaning from the crime scene photos and other evidence, Mr. Rohde, you used your wife's body as a show house to sell the concept that she had taken her own life. You methodically and clinically went about in an attempt to create the indelible impression that Susan had done this to herself. Preparation was clearly key, and you had one chance to make the impression you wanted, and you went for it. I carefully searched through the forensic images of the scene. Her body, naked and exposed on the floor, with the indentation mark which you inflicted around her neck to create the impression that she had hanged herself. And I could not find in your conduct acknowledgement that she was your wife, the mother of your children, a woman, or simply a human being. So keen was the desire to ensure your liberty and to escape the consequences of your murderous conduct that she was, in that moment, nothing but an object used in the cause to market and sell the concept you wanted others to buy into. That being, Susan is to blame. She did this to herself. Naked and stripped of her dignity, you dragged her from the bedroom over the sisal rug, inflicting there with more injuries to her body, and undignifiedly dragged her through her feces, leaving fecal drag marks on the floor in front of her body. You posed her for her alibi to see and to be shocked by her nakedness. In that way, it is clear you ensured that the handyman you called would follow your instructions, aghast by the scene and the nakedness of this woman, and exit the bathroom without further ado or inspection, maximizing therewith the prospects that he would buy into the suicide image you had sought to create. This woman killed herself. So did Mr. William Lee, a fellow hotel guest who shortly thereafter arrived and stood at the bathroom door. Once he saw that Susan was naked, unexposed, he casted his gaze away out of respect and refrained from looking into the scene any further. This was exactly your staging plan, for others to be left with an image of a woman who killed herself. Through the act of staging, you were marketing and selling the suicide brand you had prepared for, and quite frankly, grotesquely went beyond the pale. The death and loss of such a remarkable person, a mother, a daughter, a sister, and friend, is in itself a traumatic and grieving experience. By blaming her for her demise in circumstances where you had murdered her, added insult to injury. You sought to tarnish her legacy, and by simulating her death as suicide, you left her loved ones to further suffer in their grief and speculate with anguish as to what motivated Susan in the taking of her own life. How it could be that she did not consider her love for her children and other loved ones, and in turn, their love for her when she chose to end her life. And naturally, they would have tormented in the quest as to how and if they had failed her. You showcased her, Mr. Rohde, regardless of the obligation you owed to protect her. You owed her body, you owed her dignity and her legacy. And you committed this offense in cruel and selfish pursuit to escape the letter of the law and defeat the ends of justice. In conclusion, I've considered various sentencing options. I've also considered cumulative effect and the concurrent effect of these sentences. For the reasons set out above, I'm satisfied that a sentence of long-term imprisonment is called for in these circumstances, and that the punishment meted out to you should exceed the minimum prescribed sentence of 15 years, which will meet all the objectives of sentencing and will be manifestly fair and just. Accordingly, Mr. Rohde, on count 1, you are sentenced to 18 years direct imprisonment. Turning to count 2, which is also a serious crime, you are sentenced to 5 years direct imprisonment. It is ordered that in terms of Section 280 of the Criminal Procedure Act, that 3 years of the sentence imposed on count 2 shall run concurrently with that imposed on count 1. Mr. Rohde, you are herewith sentenced effectively to a term of 20 years direct imprisonment. You are further declared to be unfit to possess the firearm. Thank you. That is my order. Court, please take the objection.
As the court pleases.
As the court pleases.
No chance to this there.
Right.